Just posted part 2 yesterday, and this is part 3. So if you watch part 2, I showed the full hearing from November 5th, 2019, which was the first time that Matt, who is Angelina's dad, and I ever went to court together. During that hearing, Matt tried to lie about his income. He didn't want to have to pay child support, so he tried to pretend that he only made $12,000 a year. And because I told the court that I had proof that he makes way more money than that, they said that they were going to reschedule us for a special hearing to come back in a couple months. So on November 7th, 2019, 2 days later, we were scheduled to come back to court for a hearing for custody and visitation in the family court. So in Connecticut, a lot of times they separate the child support stuff gets heard in the magistrate court, and stuff about divorce, custody, visitation is in family court. So on November 5th, 2019, we had our child support magistrate hearing. It did not go well. If you didn't watch part 2, you can go watch the whole hearing there. And then he was really mad at me after that. So then 2 days later, we come back on November 7th, 2019. And he was really mad. We had a chance to meet with family relations, and he basically told them that he wasn't going to agree on anything. He said that he just wanted to fight me on anything I wanted, and there was zero agreement. So the court said that we had to go in front of the judge, and the judge told us that we were going to have to do some stuff, and then we went on a recess. And so during the recess, him and I actually decided to go get lunch, and I was trying to do whatever I could to try to work things out, to try to make an agreement with him, because I didn't want to have to turn this into some big, crazy, contentious thing. I wanted us to make an agreement and the judge to sign it. And so I still don't have the audio from this hearing from November 7th, 2019, because the court is giving me a hard time and refusing to give it to me. But when I do get it, I will post that. But I do have the PDF transcript. So as you can see, this is part of the transcript here. So the court said that they were going to give us a referral. They wanted to refer us to an early intervention program because we couldn't agree on anything. And he's asking, where does Angelina live? I said that she lives with me. And he's asking if I was filing about custody and visitation. I said yes. And I guess when I had originally filed, I filed it as a visitation application because I was trying to make it so that the dad could have a visitation schedule. And then eventually I had also included custody on there, asking for sole custody. And it says that in my original application, I requested sole custody, a parenting plan, primary residency to be with me, and a visitation schedule for dad and child support. And at this point, him and I had already had lunch. We came to an agreement. He said he would not let me have sole custody. He wanted joint custody. So I said, fine. So I told the judge everything else he said was correct, except he wants joint custody. And he said that, what are the issues in dispute? Let me break it down. You're telling me the parties agree, at least this point, to share joint legal custody. And then Matt interrupts him and says, we actually agree on everything. We came up with a full agreement for everything. So he tells them we're ready to go. We have an agreement on child support, visitation, custody, and everything. This was after family relations was going to refer us to some program because they said we couldn't agree. We come back after lunch saying, oh no, we agreed on everything now. And so he says that they were rushing us. We didn't have time to go over everything. We met out after. We talked about it. We worked it all out ourselves and came back. And the court says, this is a rare occurrence, but I'm very happy to hear that. And then he says, to confirm that we had a handwritten agreement because I wrote it by hand with Matt. And then he said that he wanted to make sure that it was all put on the record. So the judge says that if he got the gist of this, we have a fairly detailed parenting schedule through January because this was November 7th. And so we talked about Thanksgiving, Christmas, and then the rest of the holiday season. And then once January started, it was going to be that dad's visitation would be worked out on a week-by-week basis of us agreeing. He also said that he wanted to pay $120 a week in child support. And then here he says that he's a private contractor. His write-offs are large. It's lower than it could be. So we came up with an agreement that's higher than the guidelines. And the court says this is an upward deviation. My question is, if you took your gross income based on your pay stubs, what would you put it in the calculator? He says that if he was to go by his pay stubs and his income, that it would be less than $120 a week, but he was agreeing to pay more than that. We said we would like shared legal custody and that I want unreimbursed childcare and medical from him, 50-50. Then Matt says that they wanted to give me a low amount of child support, which, by the way, they were saying he was, based on the income he lied and said he had, they were going to tell him to pay $30 a week in child support. It was like $34 a week, and he was trying to fight to pay $34 a week. But then 2 days later, after we had lunch together, I convinced him to just pay $120, because before we went to court, he was giving me $100 a week. And he said to me in court, he says, fine, I'll give you $120 if you put away $10 a week in a savings for Angelina. And I said, fine. And then he said that he was going to give me anything that she needed in addition to the money. He said he was also going to pay for diapers, clothes, anything else she needed. Well, that didn't happen. Then they talk about, why did I file in magistrate? I talked about how it took them so long. That's why I filed in family court, because originally I had filed through Department of Social Services because I was receiving Husky insurance, and the kids were asking that they provide child support when he stopped paying me directly. And then they took so long that I had filed for custody and child support by myself after that. So he asks about this. So after the judge listens to everything we says, he says, all right, here's what I can do today. Here's what I can't do today. What I can do today, I'm happy to do today, is enter this agreement as a temporary agreement. The reason I call it temporary, I can't enter a final agreement without financial affidavits and child support guideline worksheets. I just can't do that. Now, if you'd like, you can step outside the courtroom, go down to room 119, which is court support service center, and you can fill out financial affidavits down there and the child support guideline worksheet. And he says, then you guys can come back upstairs and I'll have the final agreement and everything ready for you. He tells us that we both have to go down there and fill out the financial affidavits, and somebody would help us with the child support guidelines, so we did. Then they come back in session. Thank you for filling it out. All right, based on the financial affidavits you provided, the presumptive amount of child support that the dad would pay mom is $55 a week. Is it still the case the parties would like to pay $120? He says, yes, Your Honor. So the judge says, what we're doing is deviating from the child support guidelines. Now, this is an upward deviation, which I'm happy to do, but I just need to specify the specific reason for the deviation, and best interests is one of the matters. I think the written agreement you've done is perfectly legible. What I'm going to do is hand it back down to you and have both of you sign it and date it. Before I do it, I'm going to write on the back that the parties shall share joint legal custody. All rights of primary residency is with mom. Then he says he's going to be repetitive. He talks about that we have the agreement, blah, 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 blah. This all works out. Do we agree? Do we agree? We all said yes. Now, this is the important part. He says, both of you are representing yourself. I'll ask you these questions. He says, ma'am, you're representing yourself, which is your right. But do you understand that if you want to, you can retain an attorney? He also says, do you understand you have the right to have a hearing and a trial before a judge, me or one of my colleagues? The judge could hear evidence, testimony, and the court can resolve issues. Do you believe that entering an agreement today, you're waiving your right to a trial and letting a judge decide these issues? Voluntarily, we said yes. He says there won't be any further court dates. This will be final. You can still come back to court and modify. The court said our agreement was fair, just, equitable, and in the best interest of our minor child. The court approved our agreement. It is now an order of the court, will be incorporated into the final custody judgment as a final order. They said that we don't have to do the parenting class. The court says, in light of the parties' representation that they're both engaged in parenting education, court will waive the requirement that they do it. He said, I'm glad you were able to work this out over the course of the day. I know it's been difficult. He says, best of luck. So follow for part 4, where I go into everything that happened after we left that day.